You've been wondering what tools you need to convince the court that it is in the minor child's best interest that he or she reside with you and that you make majority of the parental decisions for the child. My name is Attorney Danielle Pinkston. I am the owner and founder of Pinkston Law Group, and today's What You Should Know Wednesday's topic is allocation of parental responsibilities. On January 1st, 2016, Illinois made major changes to 750 ILCS, which governs family law. Okay? It's now called allocation of parental responsibilities, but before it was called child custody and then visitation. Allocation of parental responsibilities boils down to two primary areas, that is decision-making and parenting time. Illinois law now requires that parents submit a parenting plan laying out who makes majority of the child's decisions and then who has parenting time. Now, it does not have to be a win-win, or it should be a win-win. It doesn't have to be a win-lose for parents. Parents can share in making the child's decisions regarding education, health, religion, etc., and so forth. Or one parent can make majority of these decisions. As far as parenting time, it does not have to be a win-lose anymore. It could be that both parents have shared responsibilities for parenting time, where the child lives with one parent 1 week on and 1 week off, or 2 weeks on and 2 weeks off, or a month on, a month off. Again, parents can do whatever they feel is in the child's best interest, and hopefully the court will enter that order according to the parents' wishes. Now, if the parents cannot decide on who makes the decisions and also the parenting time, then the court will do it. But there's no guarantee you will get what you want if the judge has to do it. Okay? The old law. The old law, based upon my understanding of it and my, belief, is that it was a win-lose. One parent was the custodial parent, the sole custodial parent, and the other parent received visitation time. Again, it's not like that now. Okay? Now, decision-making. As I mentioned before, it's four primary areas: education, health, religion, and extracurriculars. When I say education, I mean the choice of school, whether it be a private or a public school, as well as tutors. When I say health, I mean medical, dental, vision, psychological care. And then religion. Will the child be Christian, Muslim, Hindu, or atheist? And then extracurriculars. Will the child play football, basketball, dance, hockey, soccer, you name it. These are all decision-making areas that parents have to consider for the minor child. If you are involved in a custody battle or a war, or you're getting ready to wage your own battle or war, then you need to really learn and consider the best interest factors. Again, before a court determines who makes majority of the child's decisions and who has more parenting time, they will look at the following 10 factors. The first is essentially the wishes of the parent or parents, the wishes of the child as to who he or she resides with majority of the time, the interaction or interrelationship between the child, the parent or parents, siblings, or anyone else who resides with the child's adjustment to school, home, and the community, the mental and physical health of all individuals involved, the physical violence or threat of physical violence by the child's potential custodian or person that he or she is going to reside with, directed at the child or another person, and then also the occurrence of ongoing and repeated abuse against that child, as it is listed in 103 of our Domestic Violence Act of 1986, whether it's geared towards the child or someone else, and then the willingness of each parent to facilitate and encourage a close and continuing relationship between the child and the other parent, and then whether one parent is a sex offender, which is sort of self-explanatory. Okay, so let's talk about these various factors. And I forgot one, I'll go back. And the terms of the parent's military family care plan that a parent must complete before deployment if that person is a member of the U.S. Armed Forces. Okay, so now let's go back and talk about the wishes of the parent. Okay, now if there's a custody battle or war, an allocation of parental responsibilities as it pertains to decision-making as well as parenting time, you would think that both parents had a desire and a willingness to have the child reside with him or her. Okay? However, the courts don't just look at now, but the courts will consider, well, 5 years ago, 10 years ago, or when the child was born, who did majority of the actual decision-making? Who had majority of the parenting time? Who was the caregiver? Who helped with homework, clothing, etc. So again, don't just think that you can just start right now and there's nothing major that has happened and you're going to get majority of the parenting time and time making decisions. Go back to, again, way back when the child was born. Who was that parent who was always involved? And again, really focus on whether it was you or whether it was, someone else. Okay. Number two, the wishes of the child. Now, again, it's just a factor. It's not a predominant or major factor, but the courts will consider who a child wants to live with and who the child does not want to live with. However, the courts will consider this a lot of times according to the child's maturity level and age. Okay. A lot of times children will prefer the parent who is the more lenient parent. Who will let me stay up until 1 o'clock on a school night? Who lets me do what I want to do, when I want to do it, how I want to, and where I want to do it? And again, kids will be kids. They might like the parent who is, again, the more lenient parent versus the one who is the parent who disciplines and actually spends time raising the minor child. So again, it's a factor to consider, but again, the courts don't always consider that factor unless the child is a certain age or the court feels that again, the child is mature enough to actually reason and comprehend and voice his or her opinion. Okay. In addition, the court is allowed to interview the child in camera unless a child rep or a psychologist believes that, again, it's not in the child's best interest to do that. Number three, the interaction and interrelationship between the child and the parent or siblings and those who live in the home. Again, the law is not required to consider this, but again, it's just one additional factor to consider. There is a case, and it's entitled In Re Marriage of Williams, where the court denied custody to the child's mother because she was engaged in an open and continuing homosexual cohabitation with an 18-year-old teenager who at the time was undergoing counseling for sexual abuse as well as drug abuse. So again, the courts didn't say that because you are involved in a lesbian relationship, you can't have the child reside with you. But there were other factors that were more predominant, and it was the fact that, again, the 18-year-old girlfriend was, involved with drugs and had some issues with sexual abuse. So again, that was the reason why the court felt that it was not in the child's best interest. Okay. Number four, the child's adjustment to his home, school, and community. These are very important factors. Again, the court wants to do what is best for the child. If the child has already built strong relationships with, teachers and, other friends, and is well adjusted to the community and the school, then why fix what's not broken? Why take the child out of this stable environment where they're thriving and then put it somewhere where there's an unknown? Okay. So again, if the child has been well adjusted to, again, the school, the neighborhood, and has lots of friends, then again, that's a very important and strong factor you want to focus on. The mental and physical health of all individuals involved. Again, a lot of times we just really focus on the mental health of the other party, but also the physical aspect of that person is important as well. And again, the courts will consider both the mental and the physical. There is a case, and it's In Re Marriage of Ford, where the court felt that, again, it was not in the father's best interest, the child's best interest to be put with the father, because the father had issues running, jumping, hopping, or playing certain sports. And again, it was in the child's best interest to be with the parent who was more stable and able to look after him a little bit more. Okay. Number six, the physical violence or threat of physical violence by the child's potential custodian, whether directed against the child or someone else. Again, domestic violence is real. People endure this on a daily basis. The court is not prone to put someone in a home where there is violence geared towards the child or anyone else in the home. So hopefully, if that is you need to get help immediately. But again, if you know this is occurring, then I would really use that factor to show the court that, again, it's in the child's best interest to be out of that environment. Okay? So again, keep in mind that physical violence or a threat of physical violence towards the child or anyone else, that's a major factor. Now, before our law changed, the child had to actually witness this violence. But now, as long as there is a real threat of physical violence towards anyone in the home, that is a very, very, very substantial factor for the courts to consider. Number seven, the occurrence of ongoing or repeated abuse as defined in Section 103 of the Illinois Domestic Violence Act of 1986. Whether, again, directed towards the child or anyone else, our courts take this very seriously and, again, want what's best for the child. Number 8, the willingness and ability of each parent to facilitate and encourage a close and continuing relationship between the other parent and the child. This is also very, very, very important. Both parents should know that, again, it is in the child's best interest to be actively involved with each or both parents. That is key. So if one parent is restricting or limiting or is violating visitation or parenting time of the other parent, that is very important. That should not happen. And again, you want to emphasize to the court that if the child is with this parent or that parent, that you will not be able to see the child because in the past they have done X, Y, and Z to interfere with the bond and the relationship between you and the minor child. Keep that in mind. In addition, it could be things like changing the child's last name. When a parent unilaterally changes a child's last name to theirs or to their new spouse, courts don't look at this favorably. It shows that, again, they're trying to break or rip the bond between the biological parent and the child. So, again, please do not do that. And if the other parent has done that, you want to make this, make the court aware of this actual incident. Number 9, whether one parent is a sex offender. Again, that should be self-explanatory. However, just because one parent is a sex offender does not mean the court will deny visitation completely. Now, it might be restricted. There might not be any overnights. It might be supervised. But just because you have a violent past or you're a sex offender does not mean that you can't see the child regardless, because regardless of what you've done, you're still the child's father. But again, it may very well be restricted or supervised. But again, it's not the end-all, be-all. And the final factor that I love to keep leaving out is, again, the terms of a parent's military family care plan that a parent must complete before deployment if a parent is a member of the U.S. Armed Forces and is being deployed. Okay? So you might say, that's good and all. I understand the factors, but I still have some looming questions that I really need answers to. And the question might be, can my religion, can my race, can my sexual orientation, can my wealth or lack thereof, my living situation, can this affect a court's decision in awarding parenting time or one parent the ability to make the major decisions for the child? Excuse me. Again, the answer is yes and no. Let's focus on religion first. Okay, religion is something that is dear and special to many of us. You could be Muslim, you could be Christian, you could be Jewish, or you could be atheist. And again, in Ray Marriage of Zuko, the court held that the 3-part test in Lemon versus Kurtman should be used to determine whether governmental actions violate the Establishment Clause of the First Amendment by favoring the tenets of any religion or of religion over non-religion. Okay, so again, our Constitution says that, again, no one can make you be a certain religion or even have one to begin with. So before a court restricts or does anything regarding religion, it must pass the 3-part test of Lemon versus Kurtzman, which is the factor about religion has to serve a secular purpose, and it cannot have its principal or primary effect of advancement or inhibition of a religion or another, and it cannot foster an excessive entanglement with religion. So again, keep that in mind. Next, race. In Illinois, just so you know, in the past, courts were able to consider race as a factor, but now they cannot. There's a case in Ray Palmer versus Sidoti. The U.S. Supreme Court unanimously held that private racial biases or the possible injury they might inflict on a child are impermissible considerations when determining the custody of a child. Again, the courts cannot consider racial biases or race when determining which parent is better fit. Okay, there might be a black woman, a white man, or a black man and an Asian woman, but again, the courts cannot favor one race over the other when determining who is the better fit parent for the child. Homosexuality. Well, I mentioned that case before about the mom who was not given custody because she was involved in a lesbian relationship. However, that was not the reason the child was not given to the mom. Okay. In remarriage of deal, the court considered this same situation. But again, courts have to look at homosexual and heterosexual relationships the exact same. So again, just because you're a lesbian or you're gay does not mean that you get the short end of the stick. Again, is it in the child's best interest to be with you and your partner or your spouse? The next one is wealth. If you're poor, does that mean that you just lose out completely and you can't make major decisions or have the child reside with you? Well, not in all cases. But again, it's simply one factor that the court will consider when determining if it's in the child's best interest to live with you. What about your residential circumstances? You don't have your own home, or in the home that you live in, you share with your parents or someone else. Again, this can be considered, but it does not mean that you will lose out because you do not have your own home. There was a case in marriage of Drummond, and again, the father took several pictures of the mom's substandard housekeeping habits, including mold and also spoiled food in her refrigerator. And the court said that despite this evidence, and without referencing to it, the appellate court overturned the trial court's award of joint custody and held that, again, the evidence showed that, again, sole custody should have been awarded to the mom, even though she had substandard housing conditions. Okay? Work schedules, time availability, and caretakers. Again, if you work a 80-hour week, you must think to yourself, is it in the minor child's best interest to reside with you? Children need people to be home with them, to cook for them, to monitor them, to make sure that again, their needs are being met. So if you're trying to be the primary parent who has majority of the parenting time, then you want to think about readjusting your schedule. Okay? Unilateral change in the child's last name or surname. I mentioned this before. If you go and change the child's last name on your own, no court order, no consent, the courts will look at this as if you're trying to break or tear the bond between the child and the other parent. Next, if you don't pay child support, will that adversely affect you when you're trying to make majority of the child's decisions or have majority of the parenting time? Absolutely yes. Okay. In remarriage of Sir Paru, the court awarded sole custody to the mom, specifically saying that, again, in order for custody to not be awarded to the father, then, he should have paid child support. Or I'll rephrase this. Because the father did not pay child support, he was not given custody of the minor child. The appellate court said that clearly the father's failure to pay child support is both a relevant and proper factor in determining the child's best interests. We did not receive any questions from our viewers for this week, but I hope that today's What You Should Know Wednesday segment was very informative and gave you a little bit more clarity for questions that you might have had. Again, keep in mind, this segment is not intended to take the place of a full one-on-one consultation. So if you still have some questions that are unanswered or you need more legal advice, then please schedule a consultation with me by calling 773-770-4771 or schedule online at pinklaw.acuityscheduling.com. Thank you for tuning in. I look forward to seeing you once again on next Wednesday for What You Should Know Wednesday.